shall appear in the matter of Smith and Pimlico Plumbers Ltd.
Yes. May it please your ladyships. I'm coming now to ground A, the alleged misdirection on King. And you have my basic points, but they are so important, I will reiterate them by way of opening. King is concerned with untaken leave. It establishes that if leave is not taken because it's unpaid, an in lieu remedy is available. It addresses a particular problem which arises in relation to untaken leave. And the problem was that the regulations provided no apparent remedy for someone who was dissuaded from taking his leave in the first place because it was unpaid. And that lacuna is filled by the King decision. But the King decision has no bearing on leave which is taken and not paid. For that, there is an immediate remedy. The individual can go straight to the tribunal. There's no doubt or difficulty about his entitlement, and he recovers it, we'll come to this in a moment, under the same procedural conditions that employees and workers throughout the land enforce virtually all their employment rights. There are some helpful passages, we say, for our case in the King decision. So I know you're familiar with it, but can I just take you through some passages, including some passages relied on by a learned friend. Just want to underline a couple of observations. At paragraph 14, in introducing the issue, European Court says, Mr. King worked for Sash Windows on the basis of a self-employed commission-only contract from 1st June 1999 until he retired on 6 October 2012. Under that contract, Mr. King was paid on a commission-only basis. When he took annual leave, it was unpaid. And I underline that sentence because not for the only time in the decision, the European Court treats unpaid leave as leave. It doesn't cease to be leave because it's unpaid. On the termination of his employment relationship, he sought to recover for his annual leave taken and not paid as well as taken for the entire period of his engagement. The claim was rejected. Mr. King made a claim to the competent Employment Tribunal. The tribunal distinguished between the three types of holiday which it was not disputed were not paid. Holiday 1 is the holiday accrued but untaken at the final year. Holiday paid 2 is leave actually taken between 1999 and 2012, but in respect of which no payment is made. That would be this case. And holiday 3 is the pay in lieu of accrued but untaken leave throughout the whole period of his employment. And this case, of course, was simply about holiday pay 3. As the tribunal...
Well, only by the time it reached the EAT,
yes.
There was a dispute before the tribunal, and the tribunal found in favour of the claimant
yes.
in relation to holiday pay 2,
yes.
and there was no appeal against that.
Yes. Well,
so
we don't know, your ladyship may know, but this court doesn't know what time limits were observed or not observed, whether there was a...
I do know there were no time limits observed.
Well,
there was a situation in which the claimant, Mr. King, wanted to be treated as a self-employed commission-only salesman for tax purposes, and the employer agreed, and so the parties proceeded on the basis that there was no entitlement to paid annual leave under the directive or the regulations. And it wasn't until the termination of that relationship that the claimant, Mr. King, sought to claim for that annual leave that he had both taken and not taken, on a paid basis.
Well, he was subject to the time limits, you say, and I can't speak for the tribunal that resolved that case or what principles they applied, but for present purposes, it's not the claim that went to the European Court of Justice. That was Holiday Pay 3, the undertaken leave claim.
Yep.
Regarding holiday, I'm at yes, paragraph 19. Before the referring court, it's common ground that Mr. King's a worker and that he's entitled to holiday pay types 1 and 2. Regarding holiday type pay type 3, Sash Windows claims that under Regulation 13.9a of the 1998 regulations, Mr. King was not entitled to carry over periods of untaken annual leave into a new holiday year. By failing to bring an action pursuant to Regulation 31a of the regulations, Mr. King lost all entitlement in respect of annual leave, since the claim for payment in lieu of paid annual leave not taken in respect of the holiday years in question was time barred. So the focus is simply on holiday leave not taken. By contrast, Mr. King takes the view that his rights in respect of paid annual leave not taken because it would have been unpaid by the employer were carried over into the next holiday year. And I just pause again to say that the European Court entirely comfortable in speaking of unpaid holiday leave as leave. And just digressing for a second, of course, in some cases that will be realistic, in some cases not. You will have seen that in this case, there was actually a specific provision of the manual, which I can take you to, under which he claimed and was given annual leave. This was not a case where an employer ex post facto was deeming odd periods of non-work to be holiday. This was a case where the individual observed the procedure, went to the control room, said, I want my holiday, and counted it in the way that you've seen in his witness statement. So the European Court, certainly in this kind of situation, it is entirely comfortable in treating unpaid leave as leave. The question is, in Mr. King's case, could he bring an in lieu claim because he'd been dissuaded from taking it?
These paragraphs don't show that the court was comfortable in viewing it as Article 7.1, paid leave.
I'm sorry?
They may refer to it as leave, but you keep saying they're entirely comfortable. And I'm not sure what you mean by that, Mr. Jeans, because there's no suggestion in paragraph 21 that this is regarded as Article 7.1 leave.
Well, I do say it would be curious if the European Court were expressing the view that unpaid leave wasn't leave at all, that they constantly refer to it as leave. One would expect them to say he had a period of absence which the employer seeks to characterise as leave, but which, on a proper application of the law, doesn't constitute leave at all. Doesn't say that.
But Mr. Jean, surely there's a distinction between what is factually leave and what is paid leave in accordance with the obligation imposed by Article 7 of the Directive.
Well, the difference is that one is paid and the other is not. I'm perhaps labouring this a little bit too much.
Yes.
But I did just want
really helping
so
us.
It's a notable feature that the court doesn't.
We have your point about that.
Yeah, you have my point, and I won't therefore pick up all the other references.
No, I don't think.
Avoid being tedious at all costs. You may think I'm not succeeding in that. Yes. And paragraph 24.
No, we really don't need the rest of the references. Thank you.
Make the same point. If we go on to paragraph 42, here we have a paragraph that was noted by the Employment Appeals Tribunal in its judgment. In the present case, it's clear from the order for reference that the right to paid annual leave laid down in Article 7 of Directive 2003/88, is implemented in the United Kingdom by two separate regulations of the 1998 regulations, namely Regulation 13, which recognises the right to a period of annual leave, and Regulation 16, which establishes the right to payment of that leave. Following the same logic, Regulation 30, Subregulation 1 of those regulations, recognises workers' rights to two separate judicial remedies, the worker being able to bring an action before a court, either to contest the refusal by his employer to recognise his right to a period of annual leave under Regulation 13, or to argue that his employer has not paid him for all or part of that leave pursuant to Regulation 16. Now, I'm going to make a similar point about this, that again, if the European Court had thought that bifurcation was inconsistent with the right, it would have said so, instead of which it comments that it's logical and that it affords different...
It doesn't say it is logical, it says following the same logic.
Well...
And it doesn't make any value judgment about it. It's simply recording that that is the way the national procedure implements the right, which is described as a right to paid annual leave.
Yes, it is a right. And let me say straight away, of course we accept it's a right to paid annual leave. And of course we accept it was infringed by Pimlico Plumbers. The only question is, what's the remedy? That's the only question. And in paragraph 44, in a situation in which the employer grants only unpaid leave to the worker, such an interpretation of the relevant national remedies would result in the worker not being able to rely before the courts on the right to take leave per se. To do so, he would be forced to take leave without pay in the first place and then to bring an action to claim payment for it. And that is the vice which the European Court is remedying here. In paragraph 46, a fortiori, in the case of a worker in a situation such as that of Mr. King, the national remedies are interpreted as indicated in paragraph 43 above. It's impossible for that worker to invoke, after termination of the employment relationship, a breach of Article 7 in respect of paid leave due but not taken, in order to receive the allowance. A worker such as Mr. King would thus be deprived of an effective remedy. Again, it's stressing the specific lacuna in the protection.
Well, what about the words a fortiori? Don't those words suggest that that's just one example?
It's the example that's pertinent to the present case, and it's the example it's addressing. And in the light of the considerations, the answer to the first question is that Article 7 and the right to an effective remedy set out in Article 47 of the Charter must be interpreted as meaning that in the case of a dispute between a worker and his employer as to whether the employer is entitled to paid annual leave in accordance with Article 7, they preclude the worker having to take his leave first before establishing whether he has the right to be paid in respect of that leave. We agree. He doesn't have to. But if he takes it, he could make a claim. It really is as simple as that. Would your ladyships forgive me if I take a little swig from a bottle here? We don't have a glass. Of course. Slightly undignified. Thank you. Similarly, we have no quibble with paragraph 60 to 64, on which reliance was placed. There is one slight difference that's just worth noticing between the cases at hand. Paragraph 60 must be noted that the assessment of the right of a worker, such as Mr. King, to paid annual leave is not connected to a situation in which his employer was faced with periods of absence, as with long-term sickness absence, would have led to difficulties in the organisation of work. On the contrary, the employer was able to benefit until Mr. King retired from the fact that he did not interrupt his professional activity in its service in order to take paid leave. And it returns to this point, what it calls the unjust enrichment point later. Now, there is a difference between Mr. King's case and our case. In Mr. King's case, at least as regards holiday pay 3, Sash Windows was getting the penny and the bun. It was getting his work in relation to holiday pay 3 and not having to pay him holiday pay. In the case of somebody who's absent, it still escapes the holiday pay until it's claimed, but he doesn't get the work because ex hypothesi the individual is away.
So it's less unjustly enriched, but nonetheless unjustly enriched.
Unjustly enriched until
to a lesser
the
extent.
remedy is
Well,
awarded.
if the remedy is available, if the individual doesn't bring his claim each time within the 3 months that are set by the regulations, and does not keep bringing that claim, notwithstanding whatever delay there is in the domestic procedures to resolve it, all the way through his employment right to the end, he loses it.
That is true of a huge range of domestic and European rights. Maternity leave rights, antenatal leave rights, all supported by European directives, have these time limits, and they require you to go to the tribunal within 3 months. Now, of course, it should also be noted that, of course, once the individual does go to the tribunal and establishes their right in principle, it may well be that they don't have to go back again. It will serve as a test case. So it shouldn't be assumed that on every occasion the individual has to make multiple applications.
Well, the omens aren't very good if you look at the history of this litigation.
Well, you know, sometimes you'll have to, and sometimes you won't. But all that is being expected is all that is being expected of any English worker trying to enforce unemployment rights. There's no difficulty in understanding that he has to go within 3 months. And if one is going to say, well, English law rights shouldn't be restricted to 3 month limitation period, or they should never be restricted where they're connected with a European right, then this is going to be a very important judgment indeed.
I wasn't sure that we were being asked to say that, but there we are. In
That's-
fact, I was pretty confident we were not being asked to say that.
That-
So I don't think you
that
necessarily
is-
need to address us on that unless one of the council on the other side stand up and say
We're
that
not
that's
saying
something we're going to have to... Well, you
No,
don't
well,
need to be going into that then.
They may disavow that, but it is the logic. If you're going to
Well,
say,
if it's not their case,
well,
you're saying it's an inevitable
their
consequence, are you?
has to fit into the overall legal system.
So
People
is
would-
your submission that that's an inevitable consequence of the way they are putting their case?
In broad terms, yes.
Okay. Thank you.
I'm going to come to effectiveness in due course, and I'll perhaps look at that in a little more detail at that stage.
So you're saying, just so I've got your submission crisp. So your submission is that it's an inevitable consequence of the way that the appellants put their case that there is a de facto challenge to the regulation, the domestic regulation.
There is a challenge at least to domestic time limits which are connected with the enforcement of European-based rights.
Thank you.
And it may go wider. do say that their attack, if it is on the 3-month limitation period, has to be coherent, and it has to reflect the overall landscape. So, coming back to paragraph 61, the European Court says, even if it were proved that Sash Windows wrongly thought Mr. King wasn't entitled to paid leave, that's irrelevant. We entirely accept that. Against that background, you say it's clear that the very existence of right to paid annual leave can't be subject to any preconditions whatsoever. We accept that. Follows from the above that unlike a situation of accumulation to entitlement to paid annual leave, a worker who is unfit for work due to sickness, an employer who does not allow a worker to exercise his right to paid annual leave must bear the consequences. We accept that, but the consequence is a claim made in accordance with the time limit. The fact that this individual didn't make such a claim doesn't create the need for intervention. He has a claim for non-payment. All he has to do is bring it. And the Advocate General's view was the same, reaching her conclusion at paragraph 78, if one turns to the IRLR report. Yeah. Advocate General, question 2 should therefore be answered to the effect if the worker does not take...
Sorry, where are you reading from?
Paragraph 78 of the Advocate General's report. Question 2 should therefore be answered to the effect that if a worker does not take all or some of the annual leave to which he is entitled in the leave year, when any right should be exercised in circumstances where he would have done so, but for the fact that the employer refuses to pay him for the period of leave he takes, the worker can claim that he is prevented from exercising his right to paid leave such that the right carries over until he has such an opportunity to exercise it. And that, in our submission, crystallises what becomes the ratio of the decision, if one's allowed to use such a word in relation to a European Court judgment.
So you have no quarrel with that?
No. No quarrel with anything in King. It's simply addressing a different situation. And in view of your Ladyship's observations, I would just refer you briefly to the judgment of the Employment Appeals Tribunal. In the core bundle, I want to come to that a bit later, actually. I'm so sorry.
Sure.
I want to come to that in a different context. Can I go on to look at Shibzu and Kreuziger?
Which are you going to first?
I'll go to Shibzu first, or Shimizu, which is at tab 43. And the issue here was whether the individual had waived his in lieu right to payment on termination by not positively claiming. And of course the directive provides for an in lieu payment for what is outstanding in your final year. And not surprisingly, the European Court says that it's not to be taken to be waived lightly. And it makes that point in both of the decisions at paragraph 55 on our page 821 of Shimizu. As it follows from the considerations that both Article 7 of the Directive and as regards situations falling within the scope of the Charter, Article 32(1)(2) thereof, must be interpreted as meaning that they preclude national legislation pursuant to which the fact that a worker has not requested to exercise his right to paid annual leave acquired under those provisions during the reference period automatically entails, without prior verification, that the worker has actually been given the opportunity to exercise the right. The consequence that the worker loses the benefit of that right and accordingly his entitlement to an allowing paid annual leave not taken in the event of the termination of his employment relationship. Again, it's focusing on leave that's not been taken and expressing a conclusion about the circumstances in which that might be waived. And at paragraph 56, by way of qualification, on the other hand, where the worker has refrained from taking his paid annual leave deliberately and in full knowledge of the ensuing consequences after having been given the opportunity actually to exercise his right thereto, the relevant provisions do not preclude the loss of that right. Now, we say nothing very surprising there, again, about individuals who do not take their leave. They've got to be given the proper opportunity and are not taken to have waived it.
Paragraph 55, just going back to it. When you look at these judgments through the prism of a single indivisible right to paid annual leave, can be read as not being given an opportunity to exercise the right, whether you take unpaid leave or whether you don't take the leave at all, can't they?
In my submission, not, because the context which is being addressed is somebody who is not taking leave.
But that's just, they're the opposite sides of one single coin, aren't they? You have a single right to paid leave, and there are two ways that you can be deprived of that right, either by taking the leave without being paid or by not taking it at all. And although the factual situation may have been one in which the leave was not taken, the European Court was as concerned, wasn't it, with those who don't get the benefit of the pay because this is a health and safety provision that requires the pay to ensure the appropriate rest and relaxation.
2 points. First, that the context of the case was untaken leave. But secondly, accepting everything your ladyship says, the question is still, what is the appropriate remedy?
But if you're looking at paragraph 55 and you ask the question, has the worker been given the opportunity to exercise the right? No. The employer denies worker status and the worker can't exercise that right all through those years of employment.
The worker has partially exercised it.
There's no such thing as partial.
Right.
It's a single... On this argument, I'm not saying I've reached any view, but on this argument, it's a single right. There's no such thing as partial.
All right.
It's either taken or it's
that.
not taken.
Then the question becomes, when has the right been infringed? And it's been infringed, not when he took the leave, because that wasn't an infringement, but when he didn't get paid for it. And it is the non-payment, to use an English term, which constitutes the cause of action. Even accepting everything your ladyship says, single right, indivisible, it's been breached. You've got to ask in what respect has it been breached? And it's been breached by non-payment. And the regulations would surely be non-compliant if they didn't say that having taken leave and not been paid for it, the worker couldn't sue for payment. Plainly, that is compliant with the directive and the charter to invest the worker with the power to pay. So, accepting all that, it still leads to the question, what's the remedy? And the obvious remedy for non-payment is a right to recover the money. We say this really can't be controversial.
Well, it depends how you characterise the right. If the right is a right to paid leave, then you could argue, potentially, that the right's infringed by an agreement which doesn't provide for paid leave.
Yes, but that would not make the regulations non-compliant in saying that the employer is in breach at the moment when it fails to pay. Or maybe it's in breach earlier and some declaratory relief ought to be available. That's not this case, but perhaps. But it would be non-compliant with the directive for the UK regulations not to confer a non-payment remedy. And it would be out of line with other provisions of the Working Time Regulations and the system of remedies for employees, workers generally, not to say that that claim's got to be brought within 3 months of the breach. And of course, if one said, oh, well, actually the breach happens the moment he enters into a non-compliant contract, well, that would bring the limitation period forward to the detriment of the worker. So the regulations are being generous in saying, well, you can wait till you're not paid before you make a claim.
Well, I mean, there's a continuing breach, isn't there?
Well, the system is non-compliant, but the infraction, the relevant infraction, is a failure to pay for a particular holiday on a particular date.
But what do you say about my lady's point that it's a continuing breach? If you have an employer who fails to pay appropriate salary each pay date, you wouldn't time the employee out after 3 months of employment. You would say that there was a continuing breach all the way through the employment, and the employee would be entitled to claim the lost wages or damages in lieu at the end of the employment.
You've got to look in our submission at in what the breach consists. And as far as holiday is concerned, it always consists in the either the refusal of a holiday or the non-payment or a particular holiday. And
well, that's the way it's framed in the domestic remedial scheme.
That is not the way the European Court sees it.
Well, the European Court has never addressed.
Well, it talks about a single indivisible right.
Yeah, but there are many single indivisible rights. In domestic law, the right to take paid time off for trade union duties, or the right to paid maternity leave, or even moving to a common law example, the right to receive paid termination on termination of employment. And the fact is that you can breach that single right in different ways. You can breach it by not giving the notice, which gives rise to a damages claim subject to mitigation and proof of loss, or you can breach it by not paying the notice money, which gives rise to a debt claim.
Yeah.
And that's an illustration.
But what do you say about the continuing breach point my lady put to you?
Well, in my submission, it's not meaningful to speak of failure to pay for holiday other than by reference to the particular occasions when holiday is taken. All you have is a potential for breach, but the breach occurs in our submission when the holiday is taken.
So if
somebody who
someone
went to the tribunal and said, "I've got a non-compliant system," in our submission would not have a remedy.
So if you get an example, as sometimes happens, that a woman has not got childcare on a Friday, and so she decides she's going to use her, in inverted commas, annual leave, or take time off every Friday for the next 6-7 weeks. On your analysis, she has to make an individual claim within 3 months. Hopefully she's got a very efficient electronic diary with reminders on it, in respect of each Friday.
Yes, she does.
Yep.
I appreciate your ladyship regards that as an unattractive feature, but it is certainly the way the UK system is structured. Now, I understand the point that your ladyship puts to me, but in my submission, there's nothing in King or Shimizu or Kreuziger which is addressing the situation where an individual has actually taken the holiday and not been paid for it. It's making the point in relation to untaken leave that the right won't be sufficiently protected if you allow it to be lost in circumstances where the individual hasn't genuinely waived it. And that's the distinction that's being drawn in paragraphs 55 and 56 of Shimizu. And it's essentially the same distinction that's being drawn in Kreuziger. And again, this is a question really as to when an individual waives an entitlement that they clearly have in the final year of employment to be paid the balance of holiday untaken. And it's at paragraph 52 on page 908 of our internal bundle, tab 45. Paragraphs 52 and 53. To that end, as the Advocate General has observed, General Bow, the employer is in particular required, in view of the mandatory nature of the entitlement to paid annual leave, in order to guarantee the effectiveness of Article 7, to ensure specifically and transparently that the worker is actually given the opportunity to take the paid annual leave to which he is entitled, by encouraging him formally, if need be, to do so, while informing him accurately and in good time, so as to ensure that that leave is still capable of procuring for the person concerned the rest and relaxation which it's supposed to contribute, and that if he does not take it, it will be lost at the end of the reference period or authorised carryover period, or upon termination of the relationship, where the termination occurs during such a period. In addition, the burden of proof in that respect is on the employer. Should the employer not be able to show that it's exercised all due diligence in order to enable the worker to take the paid annual leave on which he's entitled, it must be held that the loss of the right to such leave, and in the event of the termination of the employment relationship, the corresponding absence of a payment in lieu of the annual leave not taken, constitutes a failure to have regard to the articles. Again, the focus is on because the subject matter of the case is about leave not taken, and it's simply saying nothing about what your remedies must be if you're not paid. But we do say that it's the most logical remedy in the world for non-payment that you have an action for non-payment, and that the regulations would be non-compliant if they did not provide for such relief.
Thank you.
Learned friends are not advancing an argument that there's a lack of equivalence as between UK and domestic law in this regard. So they're accepting that the English law rules do not infringe the principle that the domestic rules must not be less favourable than applicable to domestic rights, and they're not. So, sorry, I've expended quite a lot of energy in saying that those three cases don't take us anywhere. But I do want to be very clear that we are, as it were, putting our hands up and saying this was a breach of the directive. You don't have to worry about burden of proof or any such thing. There should have been a payment. And even if one wants to treat it as an indivisible right, use that language, it doesn't make any difference, because you've still got to ask, well, what's the breach? And if the breach is non-payment, then non-payment remedy is entirely appropriate. And nobody's asking for a declaratory remedy. And there's no need for an in lieu remedy, because the leave has been taken and the payment remedy has been there all along. The difference in the cases we've just been looking at is that the individual couldn't exercise a payment remedy because they hadn't taken the leave. I appreciate your ladyships have got that point, but it is fundamental, and we do not shrink from the simplicity of our position. We were interested to note the redraft of the regulations which the learned friends have handed up. I don't know if you've got that to hand, ladies. Just to remind you, paragraphs 14 and 15 were inserted into sub-regulation 13. What the EAT accepted had to be read in the light of Lana and Plum. And they were, in fact, drafted by my learned friend, Mr. Smith, and they will be his contribution to the legislature if the legislature, in fact, enacts them. But in the red type, we've got what my learned friends put in, and in Regulation 16, we have this, and I think authorship of this is claimed by Mr. Ford as being the product of his part of the argument. It says, where in any leave year a worker does not take all the leave to which he was entitled under this regulation, the worker shall be entitled to carry forward such untaken leave into subsequent years. And pausing there, this is again premised, don't criticise it for this reason, and it's premised on somebody who has not taken the leave. Notably, again, it treats unpaid leave as leave. It doesn't proceed on the basis that it simply doesn't count as leave at all. It simply says if you don't take the leave to which you're entitled, then you're entitled to carry it forward. And we say that just...
Is the all significant?
I'm sorry?
Is the all significant in the first line? Does not take all the leave?
Yeah, well, not in our case, because there's no claim. You'll recall this is my first submission. There's no claim for in lieu entitlement. The tribunal was simply ruling on a claim for payment, and that is why Regulation 16, I'll come to 17 in the context of effectiveness, just doesn't bite on our case.
Thank you.
Part payment. We had two opposite answers delivered with equal confidence by my learned friend Mr. Glynn to the Tribunal's question. Well, what happens if there's a part payment? Take this case. Take someone who is paid, some people are, as a first aider, that's to say, they've got the qualification and they get a little allowance, 50p or a pound a week, just to be the person who administers the kiss of life on the stairs when someone has an accident. And that allowance is left out of their holiday pay calculation for 15 years. But they take all their holiday, it's paid, except that it's deficient in not taking account of that pound or 50p. If part payment constitutes a failure to grant the holiday, the individual can then go along 15 years later and say, you owe me 15 years worth of paid holiday. I've run up 300 days, so I'll have the whole year off, please, and you've got to pay me again. You were a few pence short for the last 15 years. Got to pay me again. That we would submit would be an absurd outcome, but it would be consistent with the line of European Court jurisprudence on the importance of paying normal pay as holiday pay. If my learned friend says, well, it wouldn't, it would still constitute paid leave in that case. It's only where there was a very significant shortfall. Well, how significant would significant be? What about the case of, perhaps common case of somebody who's essentially on commission, but they're paid a small retainer as well? They're not paid their commission over the years. Are they entitled to come back and say, I should have now all my holiday for all those years and paid at full pay? Is there no account to be made for double recovery? So in our submission, it gives rise to enormous difficulties if one distinguishes between the amount that's paid, but conceptually, it gives rise to perhaps even greater difficulties if you distinguish between complete non-payment and partial payment. Because of the jurisprudence of the European Court, the holiday must be paid and must be paid at normal rate. Extraordinary to say that an employer who pays a peppercorn, a very small sum, is not liable for the accumulated holiday leave, but that the individual who pays none is so liable.
It's unlikely that you would have an employer who paid a small sum or part of the sum. It's unlikely that that employer would be disputing altogether the worker's entitlement to be paid. Whereas if there was a complete refusal to pay, that may well stem from, and it did in King and it did in this case, the employer's refusal to recognise that the individual was a worker with that right. Is that a distinction that can safely be drawn?
I mean, in my submission, not. One can't get into the subjective approach of the employer, whether he's intending to breach or not, whether he's...
Well, it's not subjective. If the employer pays something, there's a recognition of a right.
Well,
it may be that that he's miscalculated it or he's misunderstood the full basis of the right. But if there's no payment, the inference is that there's no recognition of the right in the first place.
It may not. Sorry,
no. Sorry.
It may not involve the recognition of a right at all. He may simply have contractually committed to pay a retainer throughout the year, not thought of it as holiday pay, but of course it forms that function when the individual goes away. But he has refused to pay the balance. And in my submission, one simply can't distinguish between those situations. And where it all leads, we say, is that there is a simple answer to all this, that the remedy for non-payment or for underpayment is to have a payment claim, not to treat the leave as untaken. It simply leads to impossible situations, either massive double recovery or distinctions which are themselves inconsistent with the jurisprudence of the European Court on the importance of paying normal pay, or distinctions according to whether the employer is intending to pay holiday pay or is simply intending to pay an amount which serves the function of holiday pay. None of those distinctions are rational or logical or workable. And it's really as simple as this, that the remedy for non-payment or underpayment is a payment claim. It makes sense to preserve the basic distinction between leave taken cases, leave denied and leave saved to the end of employment, because of the King case, what it illustrates. There would be a gap in protection if somebody dissuaded from taking leave by the absence of pay didn't take it. But that remedy completes the picture. There's no need for somebody who takes the leave not to make a claim. No reason of principle why he must or should be permitted to delay the claim to the end of employment. No reason of principle at all. Should I have another undignified sweet? It is rather warm in here. Thank you.
Yes.
Much obliged.
I'm afraid I daren't do anything about the temperature because we'll probably all freeze instantly if I do. So I apologise if it's a little warm.
The apologies are all on this side.
Sort of looking in a nervous sort of way at the temperature control.
Yeah. Try and comport myself with a bit more dignity.
No, just have a glass of water if you need it, or a drink of water. Right?
Yeah, thank you.
Now, where do we go from here? I mean, I think we've got your simple point very much in mind now.
Yes. Effectiveness.
Yes.
Is it practically impossible to bring a claim within 3 months? There's nothing, we say, in the circumstances which creates such a practical impossibility. And it's very notable that some of the authorities on which my learned friends rely call attention to the importance of time limits and short time limits in employment cases, and to the way in which they form part of the fundamental philosophy of employment remedies in this country. If we go to the Arthur case at tab 23, as you'll recall, as the whistleblowing case.
Thank you.
If you go to page 304, just before the passage on which my learned friends relied, you have 28. The aim of section 48.3 is to exclude from the jurisdiction of tribunals complaints that are not made timelessly. Right, here's my Lady Justice Elisabeth Laing, page 304, paragraph 28. The aim of section 48.3 is to exclude from the jurisdiction of tribunals complaints that are not made timelessly. Employment tribunals are designed to dispatch workplace disputes in a quick and relatively inexpensive and informal way. The limitation period is short. In general, a complaint to a tribunal must be made within 3 months of the act complained of. This applies to complaints under the 1996 Act and under the Discrimination Act. And of course, these matters are well known to my ladyships. But it's an interesting and true general observation that this is a general policy reflected in the legislation generally, and it features also in the Unison case at tab 47.
Sadly more honoured in the breach. But there it is. Resource does not permit of
yes
fast
and
and
no.
efficient dispatch any
it's
longer.
It's still the ambition,
It is the ambition.
and whilst the sort of cases in which your ladyship and perhaps some of us at the bar are involved in tend to be amongst the longer ones, there are still a steady stream of little. If we go to the Unison case at paragraph 55,
Sorry, which tab?
this is tab 47. This is, of course, the case about fees.
So was it paragraph 55, did you say?
55,
Thank you.
page 950 in our internal pagination.
That, thank you.
Halfway down paragraph 55, a second problem, says Lord Reed, is that claimants may not have prolonged periods of time available to them during which to save the amount to pay the fees. Claimants are expected to bring their claims promptly, in keeping with the intention that the process should be speedy. The usual time limit for bringing a claim in the ET is 3 months, starting from the date of the event giving rise to the claim. And that, of course, is true here. And because it still is true for all the grand cases that we do, that a great many individuals do bring individual claims for very small sums of money, particularly under what was the Wages Act, now under the deductions from wages provisions. I formerly had the privilege of doing some part-time sitting in Leicester Employment Tribunal, and Friday was always Wages Act day, and you would be given a list of cases, claims of sometimes £30, £20, which individuals had made, and experience suggests that those individuals were not keen to delay their claims at all, and were keen to enforce their rights as soon as could be done. So one must not think that this is an ambition that has been abandoned, speedy relief. It is intended, the whole jurisdiction is intended to assist good industrial relations in the workplace. It goes right back to the Donovan report, the introduction of the tribunal system. And the thinking is the quicker that things get resolved, the better for long-term industrial relations, and particularly in an environment where individuals may be representing themselves, there's a danger that documents may be lost, memories fade. And in our submission, the tribunal, the court should not proceed on the basis that Parliament has in any sense abandoned the notion that limitation periods need to be short in the tribunal, usually 3 months. There's a valid concern about stale disputes, and I do ask the question. Ladyship challenged me somewhat a little earlier when I made claims as to the implications of what my learned friends say. But if one builds it out perhaps just a little bit further, we passed up this morning a copy of Regulation 12 of the Working Time Regulation. This is the right to rest breaks after 6 hours, and again it's part of the enforcement of the Working Time Directive, so in pari materia with the right to holiday pay we're concerned with now. And Regulation 30 duly provides that if there's been a refusal to permit a rest break under Regulation 12.1, the claim must be brought within 3 months, in effect, of the refusal. Now, an individual may say, well, that's very inconvenient that I should have to complain each time there's a refusal, because this keeps happening. Is it really to be said that I must bring my claim in time, or having brought a claim in time, that I must keep amending it? And the answer is yes, because this is a well understood time limit sanctioned by legislative policy, and irritating and difficult though it might be on some occasions for individuals, it is the law. And there's no reason, if my learned friends are right, why they shouldn't make the same argument about effectiveness in relation to rest breaks that are made in relation to holiday breaks. Indeed, it's a fortiori in a way, that the rest break is, in principle, shorter and less significant than the holiday break. And there's all the more all the more reason why it might be said that it would be nice to give individuals a longer time in which to claim, or to allow them to reserve their claims to the end of employment if they wanted to do so. But no. And that could be, same reasoning could be applied to almost every right in the Act that's remediable through the tribunal. It could be applied to the many other European rights which are reflected in English legislation: maternity rights, agency workers' rights under the agency workers legislation, discrimination rights which are supported by the Framework Directive, and so forth. And all those rights, however minor or trivial they might appear, and it could be said, the more minor, the more ridiculous it is. Every time I'm refused time off, or every time my employer is difficult about my antenatal appointment, the more one says, well, that shouldn't be subject to a 3-month rule. for the same reason, that it's making somebody's rights difficult to enforce, the more one sees that a learned friend's case really is a challenge to the way in which the legislation is structured in this country. Certainly for the working time regulations, but also for the huge body of other legislation which enforces European rights, and it might be said other legislation which doesn't. The fact is that a short limitation period has been chosen to reflect legislative policy. And whilst you might think it's not worthwhile to go to the tribunal over one rest break or one holiday, departing from the principle would of course open up a whole range of other legislative concerns. Parliament legislates very specifically when it thinks it's necessary to delay an entitlement until the termination of employment. It does that in relation to equal pay. It says that a claim for equal pay can be brought within 6 months of the end of the termination of employment. So a woman doesn't have to confront her employer over that. But almost everything else has to be claimed when the breach is committed. And in each case, the breach consists of the denial of the right or the withholding of the payment. And the learned friend's challenge is a challenge to the whole philosophy of the legislation as it applies to both European and non-European rights. The Employment Appeals Tribunal addressed this. It may be that you don't specifically recall that passage, so I'll just take you to it. I'll come back to it. I'm sorry. I'll come back to it. So I'll come back to that in a slightly different context in a moment. So what we say is that there is a perfectly effective remedy, and the fact that some claimants might prefer to be able to delay their claim until termination of employment falls far short of rendering the remedy that is on offer in breach of the principle of effectiveness. The learned friends concede that it's in line with the principle of equivalence, that it's equivalent to relevant domestic rights. Can I now come to the argument that non-payment of an in lieu entitlement formed part of a series of deductions with earlier non-payments. This is the route in to attack Bear Scotland. I'll deal with Bear Scotland in a moment. But my learned friends say, well, there's an in lieu claim which is in time, which can be linked with earlier non-payments to create a series of deductions. Now, the fundamental and basic problem with that is that there isn't an in lieu claim. There's only a non-payment claim. As the tribunal had held, and as Mr. Justice Choudhury held, the claim was straightforwardly a claim for non-payment. It wasn't an in lieu claim. So the whole premise of the argument, we say, disappeared. Mr. Ford accepts that there has to be a Regulation 14 claim pleaded before this argument can even begin to run, and there isn't one. So this is as dead a dead parrot as ever there could be. Further, you may think it's perhaps unnecessary for me to go further, but I will, to cover all bases. Your Ladyships may think it would be, in any event, an inappropriate argument to entertain when it wasn't run below. The argument that was run in the Employment Tribunal, as you'll be aware, was that the claim was in time because it was said a holiday had been taken on the 2nd of May. Alternatively, it wasn't reasonably practicable to bring the claim in time. Those arguments failed before the Employment Tribunal, and they failed again in the Employment Appeals Tribunal. And there's no appeal to this court, either against the determination that there wasn't any holiday within time, or against the finding that it wasn't reasonably practicable to bring, that it was reasonably practicable to bring the claim on time. But so what my learned friends have done in this court, having not raised it in the Employment Appeals Tribunal or anywhere below, they've sought to say, well, if we are right in saying that there is an in lieu claim that can be linked with earlier non-payments as a series of deductions. But we say that that would be inappropriate. I've handed up to your Ladyships the application for leave to appeal to the tribunal that was originally to this court. Sorry, the leave to appeal to this court, which was originally made to the EAT, so it was addressed to Mr. Justice Choudhury, seeking leave to appeal to this court. You'll see it's a letter from Claimant solicitors dated the 24th of March 2021. And if you go to ground C was an attempt at that stage to pursue a reasonable practicability argument. And ground D was the Bear, Scotland and Fulton argument. But paragraph 13 begins by saying it's accepted that this ground depends on ground C succeeding. Now, not only did ground C not succeed, leave was refused in relation to ground C, and Mr. Justice Choudhury explained in his order why that was so. If you go to page 129 of the core bundle, second paragraph of the reasons for decision, provisions refused in respect of grounds C and D, whether or not it was reasonably practicable. The claimant to brought his claim in time is essentially a question of fact. Don't consider there was any error in the tribunal's application of Biggs. Principles are well established, etc. There's no real prospect of success, nor any other compelling reason to grant permission. The claimant accepts that ground D depends on ground C, and it follows that permission must be refused for ground D. Now, having had their permission, their entry point to the Bare Scotland point refused by Mr Justice Choudhury, it is then brought in by a side wind in a renewed ground C in the notice of appeal to this court. If we go to page 17 of the bundle, Ground C is a new attempt to argue on the facts that there was or should have been a claim for untaken leave, an in lieu claimant. And then ground D says, well, we can now rely on a series of deductions and attack Bare Scotland using the, it would now seem from the skeleton argument, using the supposed...
Chris, could you just read 15 of the, sorry, paragraph 15 of the...
Sorry, paragraph 15 on page
19.
In the circumstances, the EAT and EAT should have held that the appellant could link the failure to pay the sum under Regulation 14 in respect of annual leave on termination of employment with the past failures to pay him any holiday pay. So that's the way it was. That's the way it was done. And I don't dispute that leave was given by the court for that. But the consequence of the way in which the matters developed is that neither the Employment Tribunal nor the Employment Appeal Tribunal has made a judgment on this point as to whether an in lieu payment claim, if it had been made, could be linked with earlier non-payment. They simply haven't addressed it. And we do say, certainly in the case of importance, it should, this is something which needs first to be addressed. First by the tribunal of fact, because series of deductions, everybody agrees, raises questions of fact. But secondly, by the EAT as the specialist tribunal. It would be, we say, heterodox to consider a point in the Court of Appeal which the EAT had not itself had the opportunity of addressing.
Unless there was only one inevitable conclusion.
Unless there was only one inevitable answer.
Yeah.
So we do say, it's a roundabout way, I'm afraid of saying it, but we do say it's that even if they had made a Regulation 14 claim in the ET1, it would be procedurally inappropriate for this court to address the new argument that it can constitute a series of deduction when taken with earlier.
So leave has been given, but you say we can't proceed on
So
that
you
case.
shouldn't. I accept that you have a discretion, of course.
And if we took the view that there is obviously a link between the non-payments because this employer refused to acknowledge that this individual was a worker with paid holiday rights all the way through until years and years after the relationship came to an end, and it was inevitable any time he took leave or didn't take leave that he wouldn't be paid and that his paid leave rights would not be recognised, so that there was only one inevitable answer to the question: is it a series on just ordinary reading of that word, leaving aside Bare Scotland? Do you say it would be procedurally wrong for us to proceed with the argument?
I accept it's in your ladyship's discretion, and plainly the circumstance that you describe, where you took a clear view on it, would be a circumstance that might incline you to exercise your discretion. I don't want to put too much on this point, but I do want to say, well, I've got some observations to make in a moment about this point, and I do want to say it's not clear. It is a question of fact and degree and circumstance, and it's not appropriate for an appellate court to make a judgment. So, dealing, as it were, with the suppositions on which your ladyship's point was put, we don't accept those suppositions, but we do accept that you have a discretion and that formal leave has been given. But I just draw your attention to the fact that it's come to you in rather an irregular way. Now, what we say about this, and I think this might be regarded as a moderate submission. What we say is that non-payment of an in lieu entitlement is not necessarily to be regarded as part of a series with previous payment. We do say that it's conceptually distinct. An in lieu payment is a standalone payment. It happens only once at the end of employment. It's not in the nature of a regular payment. And it's rather odd to describe a payment that only arises once as part of a series. The second general point we make is that an in lieu payment is the obverse of a payment for holiday taken. It's a payment for holiday not taken, and therefore doesn't sit naturally or inevitably as part of a series. But we do accept that it might, on particular facts, be regarded as part of a series, but we say it can't be assumed. We say a series is more than a succession. I think it was one of Alan Bennett's characters who said, history is just one thing after another. That won't do. The appellants say, and the reference is paragraph 69 of their skeleton at page 43, no need to turn it up, that a series is things which follow each other in time. That has an echo of the Alan Bennett joke. Anything which doesn't happen contemporaneously follows something else in time.
Of a kind.
There has to be an intrinsic link.
So could you just give me that reference to the appellant's skeleton argument again for my note?
Page 43 of the bundle, paragraph 69.
It's not quite according with my recollection.
It doesn't say that. It says, it says a number of things of a kind which follow each other.
Yes.
Thank you.
We say similarity of subject matter isn't enough. Episodes of EastEnders and Coronation Street may have much in common, but they're not part of the same series. Series is an expression which, like elephants and postboxes, is more easily recognised than defined. But you do need more than similarity of subject matter. And we do say that in the ordinary case, a payment in lieu is to be contrasted with a holiday pay payment. And it can't be assumed to be part of the same series.
Okay.
Clearly, if there were circumstances, for example, if the defect in the calculation were due to the same allowance being omitted, well, that might militate in favour of series, but not the mere fact of the claims, we say. But supposing we're wrong about that, and we are now on a third cumulative hypothesis, because I do stress that the basic case here is that there was no in lieu claim. So all this, we say, it is irrelevant, but I want to address the points that have been put, and so that your ladyships have my submissions about them. What about the 3-month gap, the Bear Scotland point? We say that Bear Scotland is correct. We say that it's misleading to make a comparison with, for example, the whistleblowing provision, which has different language and a different context. Reference was made to the Arthur case again, which we looked at in another context a short time ago.
Would you like us to go there again?
Yes, that's at tab 23. And we see that what had to be construed from the heading on page 304 was whether there were a series of similar acts. And at the top of page 305, Lord Justice Mummery says, a vulnerable employee may, for understandable reasons, put up with less favourable treatment or detriment for a long time before making a complaint to the tribunal. Not always reasonable to expect an employee to take his employer to a tribunal at first opportunity. So an act expending over a period may be treated as a single continuing act, and a particular act occurring in the 3-month period may be treated as the last day on which the continuing act occurred. There are instances of the authorities on discrimination law. He clearly has the Hendricks case in mind, of a continuing act in the form of the application over a period of a discriminatory rule, practice, scheme or policy. Behind the appearance of isolated discrete acts, the reality may be a common or connecting factor, the continuing application of which the employee subjects him to ongoing or repeated acts of discrimination or detriment. And then the example is given that it may consist of deducting money from salary. But the point we make first about this particular quotation is that it's addressing different language, series of similar acts. Act is obviously much wider than deduction, and perhaps more importantly, the context is very different. If you are subjected to one detrimental act, you may not realise that you're being victimised. It's only once a pattern has developed that you may decide that the first act and the second, as well as the third and the fourth, were attempts at victimisation. It's a much more open-textured piece of analysis. Similarly, in relation to discrimination, may not be the first act that puts you on notice or particularly concerns you. It may be the second or third, which forms a pattern which gives rise to a claim. Deductions are very specific. True it is that you're going to be more concerned the more deductions there are, but either there's been a deduction or there hasn't. You won't think, well, might this be unlawful conduct? What's the individual's motivation? How does it fit in with other things? It's either there or it's not. In my submission, one doesn't. There's no need to give an especially liberal construction when applying the rules to deductions. Bear Scotland, we say, is correct. A learned friend opened this part of the debate with a reference to the interesting industrial atmosphere and history of the Truck Act and the Wages Act. And he referred to the provisions on shortfalls in retail employment and so forth. And we say that is a relevant context because it helps to focus us on the reality that the draftsman is looking at weekly wages or perhaps fortnightly wages or monthly wages. He is expecting the deduction to be a regular matter from regular pay. There is no a priori reason why he would expect that deductions, if they were indeed connected or a series, would not happen every week or most weeks. And we say that that analysis that the learned friends conducted of the industrial history does really go some way to explaining what the legislative expectation is. But the real point in our respectful submission behind Mr. Justice Langstaff's analysis is the sheer oddity that a payment can be out of time, you've lost your rights, and simply revived, put back in time by later events. The limitation periods are underpinned by the principle of certainty, principle of legal certainty, which the European Court of Justice is always telling us is a fundamental principle also of European law. And a party always needs to know when the date has passed for it to be liable. And that the oddity of saying that a gap of more than 3 months will not break the series is that it simply allows claims to be revived in a way that's inconsistent with the policy of the legislation of allowing claims to be brought quickly, and is inconsistent with the principle of certainty and the ability to rely on a limitation period as a defence. On particular facts, it may also discourage employers from repeating a benefit if it may generate a fresh claim in relation to a deduction which is out of time. But whether that's right or not, what clearly underlies Mr. Justice Langstaff's reasoning, and we say rightly, is the principle of certainty.
Are you going to take us to the provision and show us where the parliamentary intention to enable Mr. Justice Langstaff to reach this interpretation
call up
is there?
a genie from the language.
It's just not there, is it?
No.
No, he's made it up.
Well, that comes from the American realists school of jurisprudence. But HLA Hart's answer was that judges are always bound by the internal aspect of the rule. And I'm sure that Mr. Justice Langstaff will have been guided by the internal aspect of this rule, which is it's a rule about limitation. It's a rule that's intended to bring an end to liabilities. And it's just strange to say that liability springs up again because of subsequent events. It may be attractive for claimants that should be possible, of course.
Well, it happens, doesn't it, in whistleblowing? It happens in discrimination.
Well, it happens in
where there
those
is
things.
a clear connecting factor or link.
It happens in those areas, partly because of the difficulty of deciding what the interrelation between those acts is. There has to be an interrelation. They have to be part of a continuing act, and there are plenty of cases where they've said, no, the grievance appeal was a separate thing from the grievance.
If there's no connecting factor or link, then it doesn't revive. But what you seem to be challenging is the notion that the that liability can revive. And the same is true, isn't it, where there is that connecting factor or link in the context of discrimination and whistleblowing?
In my submission, not. It's not a question of liability reviving. It's a question of identifying when the act took place, because the basis of the analysis in those cases is that the act has been a single act which has continued into the limitation period. It's not that the earlier acts have revived, or the later acts have revived a claim which would have been out of time. It's that there is a single continuing
But the
act.
philosophy is exactly the same with respect in relation to deductions, isn't it, then? There is a connecting or linking factor such that the breach has continued into the next deduction that happens, even if it happens 6 months later or a year later.
But I reiterate that in the context of discrimination, a linking factor is enough. The tribunal must conclude that there is a single act, and very often it doesn't, even though somebody says this is part of a discriminatory policy or regime. In fact, they say, no, well, this is different people on different dates, and you're out of time. It's a completely different analysis from here. There's no doubt that a deduction has taken place. It's a complete cause of action. The 3 months passes. There's no doubt that that person is out of time. The quality of the deduction doesn't change by virtue of the later deduction. All that is happening is that it is having the kiss of life administered by the later deduction.
So is your point partly that in the discrimination and whistleblowing cases, it's a question of identifying what the act is as well as when it took place?
Yes. I could take you. I'm afraid we haven't got the discrimination provisions copied for you, but the notion of an act extending over a period.
We do have them, right? Divided 6.
Oh, well, that is helpful. It's very prescient of somebody. There we have it. Page 78, section 123. A complaint within section 20, which is an Equality Act complaint, other than a complaint for equal pay, may not be brought after the end of 3 months beginning with the date on which to which the complaint relates, or such other periods the tribunal thinks just and equitable. Then it's 3 we need to focus on. The purpose of this section: conduct extending over a period is to be treated as done at the end of the period, and failure to do something is treated as occurring when the person in question decided on it. And the cases my Lady Justice Simler and I have been discussing are cases under 3A and its predecessor, where I think they're described as the continuing act cases. And I think I'm right in saying this word conduct extending over a period did appear in the earlier legislation. And you have the cases of Ames and Ilya and others which distinguish between acts with continuing consequences and continuing acts. And that's a wholly different framework of analysis from deduction, which happens when the deduction takes place and is a complete act, is undoubtedly actionable, and there's no reason to disapply the period. So what we say in this case, drawing all the strings together, is that this was a claimant who had a remedy, didn't comply with the ordinary time limit, was found to have failed to have brought it within any further period in which it would be reasonable to bring the claim, and that it was perfectly practicable to have brought the claim in time. These were conclusions of fact and judgment that were well within the latitude allowed to the tribunal and the appeal tribunal, and complications have been introduced by belated attempts on the part of the claimant's side, very ingenious ones, to treat the case as an in lieu case when that case was never being made. And once one accepts that this wasn't brought as an in lieu case, it's a simple out of time non-payment case, the remedy is a simple one: to recover your payment. You have to bring the claim within 3 months or such further period as is reasonable if it was not reasonably practicable, and the claimant failed to do that. The learned friend was critical of my learned friend Mr. Andrew Smith's submission to the Employment Tribunal at page 285 of the supplementary bundle, when he made the simple point at paragraph 60 that this was not a king case, and that once you accept it's not a king case, the claim fails. Mr. Andrew Smith was absolutely right in that simple point. It's the beginning and the end of the case, and attempts to bring down the remedial system in the United Kingdom, or to treat a claim which is plainly for payment only as an in lieu claim, are simply the product of an army of lawyers trying to rescue a case that's been lost on its facts. And it's of the utmost importance, we say, that this court applies the internal aspect of rules and recognises that this is somebody who simply failed to bring their case in time, and that there's no impossibility or difficulty about bringing the claim. There's nothing in King or in any of the authorities which warrants the transmogrification of the claim into something it wasn't. There's a couple of passages in Mr. Justice Choudhury's judgment that I was going to take you to, but I think I've covered the point sufficiently. So I'll just check.
Do please.
Yeah, thank you very much.
Anything else?
Thank you very much indeed.
My ladies, if I found a snail in my Coke can, Mr. Jeans would argue that Donoghue and Stevenson had no bearing on the case because it was a can of Coke. And then he would try and argue that the taxonomy of the snail was different. Ladies, can I take you first? Floodgates, overturning the system of employment rights, all without proper intellectual rigour at what this directive, what the rights arise from. Can I take you please first to Divider 8, the Working Time Directive? My Lady Justice Simler and Lady Justice Laing will be more than familiar when looking at the Working Time Directive and contrasting it with other employment rights derived from other articles of the treaties, Article 6 for instance, and other articles about reduction of inequalities in employment. The Working Time Directive doesn't. It derives from Article 137. It's a health and safety right. It's unlike other rights, other employment rights. The attempt by my learned friend to do so without understanding or taking you to the foundation and the article from which this directive springs undermines the broad brush submission which he made about an attack on all rights. It isn't. And then, over the page, he took you to Regulation 12, rest breaks. And you can see, can't you, Regulation 12, rest breaks is Article 3, Article 4, Article 5, Article 6, all about minimum working time and rest breaks. You can see all that. And he compared to you, didn't he? That if you did this for Article 7, you would be doing it necessarily for rest breaks in Article 4. No, he's wrong. You go over the page to Article 17. None of us took you to this article because the European Court says it time and time and time again. There is no derogation from Article 7. There is from rest breaks. There is no proper comparison to what my learned friend has shown you. There is no proper comparison to any other rights. And my learned friend starts to go wrong when he fails to see this as the health and safety right which it is. And can I take you, please, first to, it may be divided 40, but the Advocate General Tanchev in King. And it's just important to see what Tanchev says and how he... Tanchev's views on this, his opinion, is not accepted by King. King, as I hope I made clear yesterday, takes a standard prevented from exercising. But as I said yesterday, Advocate General Bowe picks up, and then the Court of Justice picks up in Kreuziger and Shimizu, what Tanchev suggests in his opinion. And I read to you yesterday paragraph 3, which is the the vulnerability of workers nowadays, as can be seen by Mr. Smith's treatment. I read paragraph 4, where his opinion was that the court should take a step that it is a duty of an employer at paragraph 4 of Advocate General Tanchev. And this is the IRLR version that looks like this. I beg your pardon. It's not the. It's the paper we handed up separately.
No, thank you. We're at paragraph 4.
Paragraph 3. He talks about flexible and casual, intermittent and vulnerable workers. Paragraph 4, on the 5th line, create an adequate facility for the exercise of paid leave. And then paragraph 5, he suggests that Article 7.2, a provision which cannot be interpreted restrictively, should allow at the termination of the employment relationship to cover the whole of the period in which no adequate facility was afforded by the employer for the exercise of the right to paid annual leave. And I'm sorry, and I should have perhaps sort of shortened my learned friend's submissions if I'd then taken you to paragraph 47 of Advocate General Tanchev. Where again he makes it clear it's for employers are bound to provide adequate facilities to workers for the exercise of the right. And then crucially over the page at paragraph 54. And I summarised it yesterday by using the example of a safe working system and machines, I said. But actually Advocate General Tanchev says at paragraph 54, at the hearing, the agent for the Commission stated that the obligation for compliance in health and safety matters lay with employers rather than with workers, and intimated that requiring a worker to bring a claim within 3 months to enforce paid annual leave would be akin to requiring the worker to ask the employer to provide a protective mask when dealing with a toxic substance. So just breaking that down, this court will be familiar. When you have a safe system of work, it is up for the employer to set up the safe system of work and then to implement it. And Tanchev was the prophet, which Kreuziger then made good on. And you can see Tanchev's conclusions at paragraphs 96 and 97. I appreciate that the answers to the questions referred I am here proposing would require employers rather than workers to take all the necessary steps to ascertain whether they're bound to create an adequate facility for the exercise of the right to paid annual leave. He understands what he's doing. He's saying, I'm flipping the burden. I'm flipping, and what my learned friend is doing is he's arguing yesterday's test on yesterday's law without understanding its foundation. And that's why he makes the submissions that he does that I'll go on. And 97 I'll leave the court to read. My learned friend and I agree that Mr. Smith could have brought a claim within 3 months. I've made that absolutely clear. That's the distinction from King, isn't it? There it was impossible. Could have. But two things. As King makes clear in the operative part, paragraph 66(1) or paragraph 47, which I took you to yesterday, the mere fact of taking unpaid leave to create a claim is precluded. So you can be sure that the law in Great Britain sets a precondition, because Mr. Smith has no claim for annual paid leave unless he takes unpaid leave. It sets an unlawful precondition. So as my Lady Justice King posed, the claim doesn't even start running. There's no claim until he takes the unpaid time off. And on the day he takes unpaid time off, he's under a stopwatch. And I agree with my learned friend, Mr. Jeans, that he then has 3 months to bring the claim. And Mr. Jeans says, well, that's fine. And then he loses it, hasn't brought the claim. He had an effective remedy. No. Just as in Kreuziger, if I can take you please to divider 45. And one goes to page 907. Paragraph 46. What happened to Mr. Kreuziger is, in the present case, it should be noted that it's apparent from the order for reference as meaning that the fact that a worker did not request to take annual leave to which he was entitled before termination of the employment relationship automatically entails the consequence that when the relationship is terminated, the worker loses his entitlement to that leave and accordingly the right to an allowance in lieu of leave not taken. Do you see? So Mr. Kreuziger loses his right to annual leave because he doesn't ask his employer. Mr. Smith loses his right to annual leave, which doesn't arise until he takes leave in breach of the directive. He loses his right to annual leave without having exercised it if he doesn't take action within 3 months. There's no question like Mr. Kreuziger has an easy job. He just has to ask his employer to take leave. So there's no dispute between us that Mr. Smith has 3 months to take action and then he automatically loses his right. Where the dispute is my failure of my learned friend to understand that before he can lose his right not having had the chance to exercise it, the employer must set up an adequate facility to encourage him to take paid annual leave, to inform him of his paid annual leave rights, and to tell him if he doesn't take paid annual leave rights, he will lose them. Mr. Jeans sees it a complete answer, those 3 months that he could present a claim to the tribunal. But what's happened in Kreuziger and Shimizu is the courts have changed the test. It's no longer up for Mr. Smith to come to the court, bowl in hand, to say, give me my rights. It's up to the employer in this health and safety right to set up a safe system of taking annual leave, to implement that system of taking annual leave. And if there's not, just as in a reasonable practical case, just as in a health and safety case, if they haven't taken that care, they're liable and the right carries over. And I was grateful to my learned friend who took you to, in Advocate General Bow, took you at page 897 of Kreuziger to paragraphs 52 and 53. And that was to make good his submission that, you know, it's paid annual leave isn't what it says. It's taking annual leave equals paid annual leave. You've had my submissions on that, but that's what he says Advocate General Bowe is endorsing. He isn't, because if you turn over the page to 898, he's clear at the first paragraph just below the indentation. In order to comply with the twofold purpose of the right to paid annual leave, twofold, namely to allow the worker to rest and also to enjoy a period of relaxation and leisure, and we know that you need to be paid for that, and also with the rule that the worker must normally be able to enjoy an actual period of rest, the second conclusion laid down in Article 7.2 of the Working Time Directive, namely that the worker has not taken all annual leave to which he was entitled on that date, that his employment relationship ended, and here's the kicker for Mr. Jean's submission, must necessarily be understood as meaning the worker has not been able to take all his paid annual leave before his relationship has ended. Now I say, with respect, and I know from the questions and from the points that the court was putting to Mr. Jeans, the court's understood, but to say that that 3 months he can sue for that right and then he loses it, to say that's the exercise of the paid annual leave right is wrong. And then secondly, the only test you apply to it is the Kreuziger test. Encourage, inform, tell it's going to be excluded. And necessarily, if you look at my drafting of, sorry, it's not my drafting, it's then from Mr. Ford's drafting, which I adopt, of the redraft. If you look at paragraph 16, that is untaken leave. If you look at that, Mr. Ford's had to put in the Kreuziger tests, hasn't he? Because he's had to put under Kreuziger, encouraged, informed him, and if he did not take it, the right would be lost. But if you look at the section that applies to my submissions, there's no Kreuziger test. Why not? Because, unlike Mr. Jean's disaster syndrome, we are only claiming for wholly unpaid leave. So you know, if someone, as a result, as Lady Justice Simler said, if someone, as a result of a dispute over entitlement, as the Court of Justice said in King, takes time away unpaid, you know the Kreuziger test cannot be met. Pimlico Plumbers cannot meet Kreuziger. The fact you take paid annual leave the fact you take unpaid time away from work by itself shows that your employer hasn't informed you of your right, hasn't encouraged you
Mr. Jeans said there may be cases where the contractual matrix might lead the employer not to pay, but nonetheless you can't assume or infer that there's a dispute over the worker's right to paid leave.
In those cases, then it may be right under the King, using exactly the same language in King, to introduce the words where there's a dispute over entitlement.
Which was the preface for your original submission.
Well, yes, because if one looks at the operative part of King at paragraph 66, question 1 is phrased in the words of, it's unlawful, Article 7 and Article 47 preclude the taking of unpaid leave where there's a dispute of entitlement. And then question 2 says you can carry over where you're prevented, but it doesn't repeat entitlement. So I don't necessarily resist, Milady, the suggestion that one might need to introduce the words where there's a dispute over entitlement. But it's very clear from my drafting, it's only unpaid leave. We're not opening any gate. King doesn't open any gate. It's very clear. So then the final point, hopefully in my reply, forgive me, my own friend took you to Shimizu, and I'm sure he didn't mean to, but he suggested Shimizu was just about final year leave. It wasn't. At paragraph, can I give you the reference? Paragraph 43, page 815. Sorry, divider 43, page 815. Paragraph 12 was a reference to 51 days of leave. So what Mr. Shimizu had done is over his long contract, his long repeated contracts, had failed to take clearly more than 4 weeks of leave. That's why he could, at least 2 and a bit years, isn't it? 51 days. And that's why he could carry that over. Ladies, unless I can help you further on, those are my submissions.
I don't think so.
Thank you very much. Yes, Mr. Ford.
My ladies, can I deal firstly with the point about what claims did the claimant bring? And in my submission, Mr. Jeans, first of all, has elided 2 issues. Was there a claim for Regulation 14 WTR as a matter of domestic law? And secondly, was there a claim for untaken or unpaid leave based on King? Because he's treated them compositely in his submissions. And I'll deal with them separately. The second thing is he's ignored the consequence of tribunal misdirection. If the tribunal misdirected itself, then the decision cannot stand. And then we consider, well, what's the consequences of that misdirection?
Well, it depends. It depends. I mean,
Yes.
it may be that you say, if the tribunal misdirected itself in relation to the true meaning and effect of King, that could cast a different light on what claims were pursued
Yes.
in the Employment Tribunal by the claimant. Is that
Well, I'm going to come to that because that you're echoing, I think, a point made by the EAT
yes?
to that effect. Yes,
Yes.
we'll come to that. Yes.
Okay, but you're making a different point.
Well, all I'm saying is you then have to consider whether you remit, whether this court decides the question, or whether you think that there's only one answer, a la Mr. Jeans. But he's not addressed any of that.
Right.
And in my submission, the analysis is different into each of the 2 points.
Right.
So if we begin with Regulation 14, well, as you know, we say the tribunal did misdirect itself at paragraph 40 in relation to the domestic law challenge, because it said that it was not possible to construe paragraph 37 as a claim under Regulation 14, when plainly we say that was wrong. So if that's right, there's a tribunal misdirection at that point, which I don't think Mr. Jeans has actually challenged. He's never taken you to that paragraph or suggested it was right. So that means the tribunal misdirected itself.
Sorry, can I just catch up and find paragraph 40, please?
Yeah, me too.
I got assailed by a bout of sneezing.
Sorry, it's page 156, my lady.
Yeah.
So para 156 is where the tribunal said it was not possible to construe paragraph 37 as a claim under Regulation 14, and it amplified that by saying it was only a claim for unlawful deduction from wages.
Well, he did take us to it.
I
Yeah.
certainly say that the tribunal directed itself correctly.
Yes.
All right, well, on the premise that we're...
Well, I mean, the whole of
Yeah.
Mr. Jeans's argument has to rely on the fact that there was a correct.
Well, if I can put it another way then, my lady, on the premise that we're right, that that's a misdirection.
I think that works better.
Thank you. Then we come, but what's the consequences of that?
Right. So if, contrary to Mr. Jeans's argument, there was a misdirection at paragraph 40,
What is the
what
what are
is
the
the
consequences?
Yeah.
And just to pass in noting, you can see there that Mr. Stevenson
Yep.
was arguing that there was a claim properly brought as a matter of domestic law under Regulation 14, because you see it recorded earlier in the paragraph. And for your note, that's also in his skeleton at 245. So that point was was argued. So the question is, what's the consequence if we're right there was a misdirection? And what we say is there is only one correct answer, and we invite this court to take itself to take the decision, in part because it's based on what the pleading means, and the alternative is, of course, yet more delay, because if this then has to go back to the tribunal for it to decide whether or not a Regulation 14 claim was properly brought on the pleading, we'll be here forever. And what we say is there's no real doubt that if you look at paragraph 37 of the claim form, which is at page 185, As an employer worker, R1 failed to allow my entitlement to paid holidays from the outset of my employment or at a later stage. We say that does capture the essence of a Regulation 14 claim. This was a continuous failing to each annual leave year up to the date of termination on 3rd of May 2011. If that paragraph stood alone, I cannot countenance there's a tribunal in the country that would say that couldn't allow a Reg 14 claim. And it's emphasised further if you go back by paragraph 21 rather, at 182. So all the weight of Mr. Jean's argument effectively turns on paragraph 5. But because at paragraph 5 at page 177, the tribunal said I took annual leave, but the respondent did not pay, all the weight of his argument is that therefore precludes a claim under Regulation 14. You cannot, because of that, claim for untaken leave on termination. But we say, well, why not? All that's saying is I took, doesn't say how much, I took some annual leave. Why on earth construe that as saying I took all of my annual leave in the leave year of termination? Any worker might take some annual leave, but that paragraph in and of itself cannot exclude a Regulation 14 claim.
Well, is the question whether it excludes a particular type of claim, or rather is it a question of whether the claim is made?
Well, he's saying because of that sentence, effectively that means there cannot be a claim for Regulation 14. That's what he places all the weight of his submission on.
Well, I mean, we heard his submission.
Yeah, we heard his submission. Yeah, but when it comes to the pleading,
Well, just one time.
I
think we'll give deference to Lady Justice Laing first.
No,
You
I
were
didn't say
saying-
anything. I mean, all I was saying was, we heard the submissions and we can make them what we will.
Yes, it's not right to say I base myself on one paragraph, and of course you have.
Well,
page
we
200.
had your detailed
Right.
analysis over
do.
probably an hour and a half about why you say there was no claim. So we have that
yes.
very much to the forefront of our minds.
Claimant's counsel himself went to the trouble of saying, for the avoidance of doubt, I'm claiming 13 and 16.
Yeah, but, well, we don't need you to rehearse
No.
what you've said. We're aware of that,
I'm
and you took
sorry.
us to various
I'm just getting
documents,
a
and
little
we have a
overexcited.
note of them.
My apologies.
No, not at all. Not
Well,
at
can
all.
I try
Don't
and-
apologise, but we have your case. I promise you we have your case.
well, can I try and put it more neutral so I don't get too excited either? But we say that sentence.
Think of your blood pressure, gentlemen.
I try a lot of meditation with that. But we say that sentence cannot exclude a Regulation.
Right.
And we say a fortiori, the words I've explained to Mr. Glynn, once the tribunal had decided he'd taken no leave after the 1st of January, once it had said, we decided you didn't take leave after that, then it shouted out, to use the metaphor of Lord Justice Bean in the Mervyn case, that there was a potentially good claim under Regulation 14.
Thank you.
So, in summary, we say the pleading does set out the essence of a Regulation 14 claim, and therefore, if you're with us on the misdirection, we invite this court to take the decision on the pleading.
Thank you.
So now we come on to King untaken. Well, in fact, the whole tribunal analysis on King, as I've said in our submissions, we say the tribunal did not decide the King point on the basis King wasn't pleaded. Rather, it decided it on the basis that in agreement with the claimant's counsel, no such claim had been brought on the facts or the pleading, because the claimant did not particularise any occasion on which he sought to take holiday and was refused. That's why the tribunal said the King claim isn't a good one. So we say, if we're right, that's a misdirection and it cannot stand. And in this respect, I hope I'm not mischaracterising Mr. Jean's submission, he has not challenged my analysis in relation to untaken. He's challenged Mr. Glynn's analysis in relation to taken and unpaid. He has not challenged any of my analysis in relation to untaken. All he did was float a possibility that on the facts, claimant had in fact said he'd taken all his leave.
Well, he says there wasn't any untaken.
Yeah, well, with respect, that can't operate because of paragraph 40 in the witness.
Well, when we've got both your submissions
Thank you.
in relation to paragraph 40.
And so that I won't say any more about that. So if we're right, that means that the tribunal decision can't stand on the King point. So it then becomes, well, what does this court do in the light of that misdirection? If Mr. Jeans was to say the tribunal decision should nevertheless be upheld because the King point in general terms wasn't pleaded, he's therefore arguing there's an alternative reason for upholding the tribunal decision which is different from the reason the tribunal gave. That would have to be the logic of his position. If the King misdirection is thrown out, he would have to say there's a different reason for upholding it. But so far as I can tell, that isn't his argument. There's no respondent's notice. There is nothing to suggest the tribunal decision should be upheld for a different reason, that the King claim wasn't pleaded in general terms. So that's the first point why we say that claim shouldn't go back to the tribunal. But if we're wrong on that, we'll also say that this court can properly decide the King point. And we say the essence of a claim based on King is set out in the pleading. And we refer to the whole pleading, of course, including the background that I was denied worker status. And we refer to paragraphs 21 and 37. 21, as a worker, I was denied paid holidays from the outset or at a later stage in my contract. We say that captures King. That is King. It's treating the right as composite to paid holiday and saying I was denied it at the outset. And it's underlined by 37 again, as an employee or worker, R1 failed to allow my entitlement to paid holidays from the outset of my employment or at a later stage. This was a continuous failing connecting to each annual leave. We say that is the essence of a King claim based on the composite right. And it's quite clear that was the claim the respondents anticipated, because as Mr. Jeans showed you, their list of issues at page 220 in the supplemental bundle anticipated a potential King claim. At 8 it refers to the page 220 at 8, the failure to pay him, and at 8.2 over the page it referred to the claimant may seek to pursue in respect of annual leave allegedly not taken, and referred to King in the footnote.
But the response to that was that the claimant was not changing or replacing the claim,
Yes.
which was to an entitlement to paid leave under regulations 13 and 16. That's 224.
Yes, but you'll notice it says regulations 13 and 16.
Yeah.
Regulation 13 isn't a claim to payment. Regulation 13 is a claim for leave.
Yeah.
So it's saying Regulation 13 is a claim for leave, and Regulation 16 is a claim for pay. So we say this is completely consistent with how the claimant's case ends up being put. And you can see the reference goes on to refer to King over the page at 226. And it's consistent with his case throughout. It doesn't matter whether he took the leave or didn't take it, he is entitled to recover it under King.
It's an odd drafting technique when the respondent expressly refers to Regulation 14 to respond by saying that you're not changing or replacing your argument or
No, but
entitlement to paid emphasised annual leave under Regulations 13 and 16.
Yes, but if you go on, it goes on in the next paragraph. Did not permit paid leave under the regulations. That's paragraph 2. Did not permit, and carries on then referring to King. And you see the same in the claimant's skeleton, which is then put into the tribunal at 245. Where he does refer to Regulation 14 and makes clear that it is in a claim for taken and accrued but untaken holiday. That's at 1A. And likewise, if you look at B and C over the page, B is about the claim for payment, and C at 246, whether in the light of King, the claimant was entitled to payment on termination in lieu of untaken Reg 13. You can delete Reg 13A, we accept that doesn't apply.
Sorry, where are you reading from?
On 246, you can,
yes,
where
B.
the top, you can see the two claims broken down in a sense. Whether the claimant's claim for payment in respect of such leave of time bar, and then whether in the light of King, the claimant was entitled to a payment on termination in lieu of untaken Reg 13. I accept Reg 13A as an error, that accrued in leaves prior to the leave year in which the claimant's employment ended. So in my submission, the claim was being put consistently to saying he's claiming for everything.
But that's the skeleton argument just before the hearing.
Yes.
And that's the first time that as I understand it, the claimant specifically referred to Regulation 14. Is that right or not?
I think that's the first reference. Yeah, that's the first reference to Regulation 14.
Right, so there's nothing in the pleadings or in the documents building on, eliciting or whatever, interrogating the pleadings that tells us that the claimant was relying on Regulation 14 until we get the skeleton argument.
Yes. Right. But we rely, as I've already said, on paragraph 37.
Yeah, no, I've got that point. Thank you.
And we also rely, in the way the AT put it, to echo the point that my Lady Justice Simler said, where the EAT said at paragraph 97, page 105, that if the tribunal had misconstrued the effect of King, that would put the whole case in a different light.
That's an alternative way of arguing.
That's an alternative way of putting it, yes. So we say in relation to King, the correct conclusion is the tribunal misdirected itself. And again, this either the respondents can't take the point or this court decides it. My ladies, that brings me on to Agnew.
So what's the Mr. Jean says none of that matters because he didn't make his claim within 3 months.
Well, if we're right on Reg 14,
then we have a
claim in 3 months, and if we're right on King, we have a claim within 3 months. So there are claims in time if we succeed on either of those grounds.
because the limitation period for the King claim runs from the date of termination, whereas
Yes.
the limitation period for the Reg 14 claim runs from
Termination too.
Well, the Reg 14
Yeah.
claim runs from the date when leave should have been paid for,
Yes,
which will be post-termination.
right.
And in fact, the tribunal made a
Yeah,
finding
okay.
on that. I think it would have been the pay packet following his termination,
Right.
which would have been in May. I think it was the pay slip following termination, yeah.
Right.
But there's no dispute. Both a King claim and a Reg 14 claim would be in time.
Yeah.
So if we're right on that, that gives the legal and factual premise to which the series can attach. And my ladies, you saw the notice of appeal. The notice of appeal was, sorry, the grounds of appeal on which permission was granted was explicit that paragraph 15, if the series point is a potentially valid one, if it can be linked with the claims that are in time. So, as to the point that, well, there is only one inevitable answer on this, a point again raised by my Lady Justice Simler, we adopt that. There is only one possible answer to the series point. Mr. Jean says, well, it may depend on a factual assessment, but I ask rhetorically, what is there to assess here? We know he was never paid when he went on leave, or holiday to describe it more neutrally. We know he was never made a payment on termination. There are no facts to investigate. So it becomes really a question of law on facts that aren't in dispute. And we say there's another compelling reason to decide this point as well, which is public interest. And can I just refer you to the passages in Stringer, Lord Roger at 21, Lord Walker at 38 to 39. Because in Stringer itself, he'd already been paid, Mr. Ainsworth had a good claim under Regulation 30, but the House of Lords nevertheless decided to hear the point on wages because they said it was of general practical importance. And so it is with this point on Agnew. As to the substance of Mr. Jean's submissions on Agnew, well, firstly, he said, well, the premise of the Wage Acts and Truck Acts was that they were focusing on wages that were paid weekly, fortnightly, or monthly. No, they're not. The definition of wages extends to bonuses, commission, all forms of payment. That's section 27. And secondly, when he talks about retail employment, that undermines his case because deductions from workers on account of cash shortages or requirements for them to pay in respect of cash shortages may occur sporadically. There's no reason to assume they will be deducted every month. They will only occur when the employer decides to make the deduction or decides to enforce the payment. So there is nothing in the wording of any of the legislation to suggest it only applies to repeated, contiguous, periodic payments. And my ladies, can I refer you for your note 57, the definition of wages? Any sums payable to the worker, any fee, bonus, commission, holiday pay, or other emolument referable to employment. So a very wide definition designed to capture all the emoluments paid to workers and not simply those that are paid every week, fortnight, or month. And nor is there anything in the wording to suggest that that's that it's restricted, the wording of section 23. Now, we won't go quite so far as to invite the court to adopt the point that Mr. Justice Langstaff made it up, but we do adopt that in substance. There is no foundation in the statutory language for the approach he took. And as for the appeal to HLA Hart, well, I'm tempted to say that the word series is a concept that is sufficiently clear in law. There is a penumbra of uncertainty, to echo Hart, but that's all there is. It's a clear concept, fact and degree, whose core components are clear. So we're not stepping out of the rule of recognition or anything like that.
That's a relief.
And finally, as regards the whistleblowing provisions, the whistleblowing provisions aren't worded like the discrimination ones. My Lady Justice Simler, but it's worth having a look at them.
48.3
48.3,
talks about the series.
the whistleblowing provisions are at page 59. This is 48.3a. Where that act or failure is part of a series of similar acts or failures. So nothing like the Equality Act definition. And if anything, narrow wording, because it talks about similar. I mean, we say that may be implicit anyway in the concept of kind. But if anything, narrower. So we're left with this paradoxical result. If a worker's bonus, let's take a triennial bonus, or once a year Christmas bonus. If that bonus is deducted because of whistleblowing, the claimant can bring a claim. And all the consequences against which Mr. Jeans argues has no effect. The 3-month period revives. It's a series, it's a series. So that worker can bring a valid claim going back in time on the basis of a series. But if that worker, according to Mr. Jeans, seeks to bring a claim under the protective legislation in the wages provisions, using similar wording, he can't. Because if it's a triennial bonus, there will always be a gap of 3 months. And much as consequential reasoning may not drive statutory interpretation, we say at the very least that's a surprising result and one that tends to support our submission on series. Unless there's anything else.
No, thank you very much
Thank you very
indeed,
much.
Mr. Ford. Can I thank you all very much indeed. This is a difficult and important case, and we are acutely conscious of that, and I'm sure you appreciate that that's been reflected in the expertise on the Constitution, from which I exclude myself. But we will, of course, reserve our judgments. I can't tell you exactly when they will be handed down. I think in reality it's very unlikely that it will be before the end of this term now, given that the importance of the judgment. They will be then dealt with in the normal way. They'll be sent out in order for you to consider any typographical, grammatical errors or minor errors of fact. It is not an invitation to treat. And I would hope that then any other matters can be dealt with in writing and with short written submissions, and that ultimately you will, between you all, no doubt your juniors, be able to agree an order. But can I thank you all very much indeed. Can I also thank those that are behind the leaders, because I'm acutely conscious of the work that's been done by the juniors and the solicitors and all the support staff to put together a case of this complexity. And having had a couple of nightmares in the last few weeks, and I particularly compliment whoever put the bundles together, because they were extremely manageable, and I've noted that we found it very easy to navigate through them during the course of the hearing, in which we've actually referred to the authorities that have been put in the authorities bundle, as opposed to just carrying them around with us. Mr. Jeans, you look as though you're hovering. Are you wanting to say something?
There's just one point,
yes, of
ladies,
course.
if I may. Just in terms of the form of order,
Yes.
I didn't address you on remission and so forth, and it strikes me that if you were partly in favour of one and partly in favour of another, there would be many concatenations.
Yes.
Could I just respectfully suggest that if there's any question that as to whether an issue should go back, whether it should go back to the same or a different tribunal, you might reserve us the opportunity at least to make written submissions about that. Yes. There plainly would be some circumstances in which it was obvious to your ladyships
Yes.
what should happen, but there might be.
No, I think that's very sensible, certainly. And if I can just say, if there's problems with the order, if we could please, if I can beg you all, if we can have one order, and then you can use whatever is your favoured method, whether it's italics and bold or different fonts or colours or whatever. It's so that to highlight the areas of dispute between you. It's so much easier for us to help you by coming to a conclusion about the proper order in that form. Anything else that we can usefully do today? No? Very well. Thank you all very much.
Goodbye.